So, we've got a stack of notes here, all about conditions in contract law.
Lots of ways we could go with this. Big negotiation coming up.
Maybe,
We're just,
maybe just,
curious about the legal stuff.
yeah, exactly.
Yeah.
A little legal curiosity never hurt anyone, right?
Right. And either way, think of this as kind of a crash course
Yeah, a crash course.
on what actually makes a contract.
What makes it tick?
Yeah, what makes it tick.
I like that.
So we're really diving deep into this idea of conditions, those like if-then scenarios
Okay.
that determine really whether or not you are bound by an agreement
Which is
or,
off the hook.
yeah, off the hook entirely.
I mean, off the hook, that has a nice ring to it. But let's be real, this is about way more than just getting out of a deal. Right?
Oh, absolutely. It's about really understanding kind of the DNA of a contract, how it all works.
Yeah.
And once you get that, you can, really analyze the risk involved,
Right.
protect your interests, and even just negotiate better agreements with a lot more confidence.
Okay, so let's break this down a little. For anyone who hasn't exactly, spent their days poring over contract law textbooks,
Right, right.
what exactly is a condition in a contract? I mean, in the simplest terms possible.
So at its core, it's an event, or sometimes even the lack of an event, but it's something specific that has to happen before a party is obligated to fulfill their end of the bargain.
Okay, so it's like a gatekeeper, kind of, for those contractual obligations.
Yeah, like a gatekeeper, exactly.
Give me an example, something a little more sophisticated than I'll mow the lawn if it ever stops raining.
Imagine this. A real estate developer wants to buy a plot of land, but they include a condition that says they'll only buy it if they can get financing from the bank.
Okay, that makes sense.
That right there is a condition precedent.
Okay, condition precedent. So that's where that term comes in.
Exactly. Until that loan is approved, they're not obligated to buy the land.
That's huge.
Yeah.
Especially when you're talking about a big purchase like that. So conditions precedent, it's all about managing risk then, especially for the party who has the most to lose up front.
Exactly. They're essentially saying, hey, I'm only jumping into this if certain things happen.
It's like a safety net, right?
Exactly, a safety net.
Mhm.
Now, let's say you're, I don't know, having a custom piece of furniture made. The buyer might include something in the contract stating they'll only pay the full amount if it's delivered by a certain date.
So that puts the pressure on the furniture maker to meet that deadline.
Yeah.
Yeah.
Otherwise, they risk losing out on that full payment. Now, on the flip side, that contract might also say the buyer loses their deposit if they cancel after a certain point. That's what we call a condition subsequent.
Okay, so condition subsequent is like an escape clause. It can end obligations or even the whole contract, depending on something that happens after the initial agreement.
You've got it. And to put it into like a real situation, say you hire a contractor to remodel your kitchen, right? But you include a clause stating that the contract is void if the city denies the permits for the work.
So even if you've signed on the dotted line, that permit denial is like an out. It protects you.
Exactly. It's about having some flexibility built in.
Right, some wiggle room.
Yeah, safeguarding your interests, especially when you're dealing with, outside factors, things you can't really control.
This is making so much sense now.
Oh,
Okay, but what about those situations where both parties have obligations and they're kind of dependent on each other?
so now we're talking about dependent conditions. And a case called Palmer v. Fox really highlights how important these can be, especially in real estate.
Okay, hit me with it.
So in Palmer v. Fox, you've got a buyer who agrees to buy a property.
Okay, sounds pretty standard so far.
And this is a big thought, but the seller also agrees to make some serious improvements to the surrounding area. Think roads, sidewalks.
So like the whole 9 yards?
Yeah, the works.
Makes sense, especially if it's a new development or something.
Right. So are you ready for what happened?
Oh.
The seller, they kind of dragged their feet.
Oh boy.
Yeah, didn't make those improvements like they promised.
I can imagine the buyer wasn't too thrilled about that.
Not at all. So the buyer, they decided, you know what?
No dice.
Yeah, basically, they stopped making payments.
Wow.
And of course, the whole thing ends up in court.
Of course it does.
And the big question was whether that promise about the improvements, the roads and all that, whether that was actually a dependent condition.
So in other words, was the buyer's obligation to pay like directly dependent on the seller doing what they promised?
Exactly.
Okay, so this is where things get really interesting. It's not just about, did someone break their promise? It's about, was that promise a make or break part of the entire deal? What did the court say? Whose side did they take?
They actually sided with the buyer.
No way.
Yeah.
So they're like, hey, seller, you messed up those improvements. That actually lets the buyer off the hook for the payments.
That's exactly what happened. The court said those improvements, those weren't just like a side promise, those were crucial.
Oh, wow.
A crucial dependent condition.
That is huge. So anyone out there buying property, take note.
Right.
It's not enough to trust that the seller will keep their word. You got to have those make or break conditions
Absolutely.
spelled out in that contract.
Yeah. Palmer v. Fox, it really drives home that point, that dependent conditions. It's about fairness.
Yeah.
It's about making sure things are balanced in the agreement. One party shouldn't have to carry the weight, but the other one's not holding up their end, especially when what they're supposed to do is so connected.
It's like, I don't know, a dance routine.
Right.
Where each person's steps
Yeah.
totally depend on the other person hitting their mark.
That's such a good way to put it.
Right.
Yeah, and speaking of hitting their marks, let's switch gears for a second and talk about conditions concurrent.
Okay, so instead of this perfectly choreographed dance,
Right.
we're talking about things that happen like at the same time.
Exactly.
Obligations that are simultaneous.
Yeah. So think about a real estate closing.
Okay.
You've got the buyer who needs the deed.
Right.
And the seller who needs the money.
Right, the cash.
Usually, those things happen at the same time.
Right. You don't hand over the deed before you see the money, right?
Exactly.
Right.
Often there's an escrow agent there to kind of,
Right, to keep things moving.
Yeah, keep everything on track.
Yeah.
Make sure it all happens smoothly.
So it's like this perfectly timed exchange. Nobody's obligated to go first.
Right.
It's all dependent on both sides being ready at that exact moment.
Precisely. Conditions concurrent. That's what they're all about.
Okay.
And, your source material had a really relatable example.
Okay.
Imagine two friends.
Yeah.
They're going to trade these rare comic books.
Nice.
Neither one of them is giving up their prized possession until
the other one's ready to swap, right?
Exactly.
Yeah.
At the same time.
It's like a trust fall, but with
Right.
with valuable comic books.
Exactly. Much higher stakes.
Right. Instead of just our fragile bodies.
So shifting gears a bit,
Okay.
sometimes a condition, it's not met, perfectly, but it's close.
Close enough.
Close enough.
Yeah.
This is where this concept of substantial performance comes in.
So like getting a B+ on a project instead of an A.
Yeah, that's a great way to put it. It's about whether someone made a real effort, to fulfill the heart of the condition, even if there are some, small differences.
Right. So it's about being reasonable.
Yeah.
Not letting those tiny details completely derail the whole agreement.
Exactly.
But how do courts actually decide that?
Yeah, good question.
Like what's considered substantial enough?
That's where looking at past cases, the case law, comes in. One of those landmark cases is Jacob and Young's v. Kent.
Okay.
Imagine you're building your dream house.
Oh, I love this.
Right. And you specify very specifically in the contract, I want this particular brand of pipe for the plumbing.
Okay.
But the contractor, they accidentally install one that's like really similar, but a slightly different brand.
Oh, no. So the dream house vision is crushed because of like a plumbing technicality.
Right. So in the real case, the homeowner, they were not happy.
I'll bet.
They refused to pay the rest of the money for the construction because of this pipe situation.
Oh, wow.
They said, using that exact brand, that was a condition of me paying you.
Right.
But the court actually disagreed.
Wait, hold on. Even though the contractor messed up, went against what the contract said, the court was like, nope, you're still getting paid.
They did. And it all comes down to this idea of, fairness and being practical.
Okay.
They said, look, the contractor, they basically did the job.
Right.
This pipe thing, it's minor. It doesn't really change how the house works, the value of it.
Right.
Making them tear down walls, replace perfectly good pipes for something this small, that's unreasonable.
Okay, so it's about looking at the bigger picture, not getting bogged down in the little details, as long as the main purpose of the contract was actually met.
Exactly. Jacob and Young's v. Kent, that case set a precedent. You can't just use these little tiny deviations as an excuse to,
Right, to get out of your obligations.
Exactly.
To weasel out.
To weasel out. That's a good way to put it.
Right. That makes total sense. But what about when the condition itself is the problem? Like, what if the condition's unreasonable? Maybe even, I don't know, goes against what's right, like the public interest.
That is a great question.
Can those kinds of conditions actually be enforced?
It's a whole other layer to this whole thing.
Right.
This idea that a condition, even if it's written down in the contract, it might not be enforceable if it goes against, like you said, public policy.
So we're talking about those times when something might seem okay on paper,
Right.
but just feels wrong on a deeper level.
Exactly. And there's a case that really shows this. Ferguson v. Phoenix Assurance.
Okay, tell me more.
Picture this. A jewelry store owner, they experience a burglary.
Oh, no.
Right. They file a claim with their insurance company
Okay.
and get denied.
Wait, what? Why?
Because, get this, the insurance company says the policy requires visible marks of forced entry on the safe
Okay.
to prove that a burglary happened. And in this case,
The safe is still locked?
well, no visible damage.
What?
Yeah.
So even though the jewelry's gone,
Right.
because the safe door doesn't have a dent in it, they're out of luck.
Yeah.
That seems, I don't know, a little harsh.
It does seem a little unfair.
Right. I mean, how do you prove that something was stolen without that specific evidence? Seems impossible.
Well, that's exactly what they were dealing with in Ferguson v. Phoenix Assurance.
Right.
And the court, they ultimately decided to support the store owner.
Oh, good.
Yeah, they said that requirement about the visible damage, that was unreasonable.
Right.
It went against public policy.
Because really, what is that about?
Right.
That just lets the insurance company, like, get out of paying for what they should be covering.
Exactly. And that's what the court said. This condition, even though it's in the contract, it just puts too much on the store owner.
Right.
It's not right.
Yeah.
It was basically a way for the insurance company to avoid their responsibility.
Wow, that is a really important point.
Yeah.
So the court can step in
I can.
and say, nope,
They can.
that clause, that condition, it's not okay.
Exactly. The court can invalidate conditions if they're unfair,
Right, like really unfair.
unjust, or just not in line with the public good.
It's good to know that there's something to prevent those gotcha clauses,
Right.
from being used against people.
It really emphasizes why it's so important to really read those contracts.
Yeah.
Especially when it comes to conditions that seem a little, iffy.
Right, or they seem like they're asking for too much.
Exactly.
Yeah.
Or could be used against you.
This has been honestly so helpful.
Yeah.
We've covered so much.
We have.
We talked about those really important conditions, precedent,
Right, the foundation.
that have to happen before anything else is even on the table.
Right.
Those escape clauses, the conditions
Would
subsequent.
you get out of jail free cards?
Right. And how important dependent conditions are to make sure things are fair, that one person isn't taken advantage of.
Yeah, absolutely.
And then we even got into, like, the finer points of
Yeah.
substantial performance.
Yeah.
And when a condition might not even be enforceable in the first place if it goes against what's right.
Yeah. It's a lot to unpack.
It is a lot. So as we start to wrap up this deep dive
Yeah.
into the world of contract conditions, what's the big takeaway here? What should our listener remember as they're navigating this often confusing world of agreements?
I think the thing to remember is this. Conditions, they aren't just legal mumbo jumbo.
Right.
They're not just there to trip you up.
Yeah, they're not just like footnotes on the fine print.
Exactly.
They're tools.
They're important. Yeah, strategic tools
Mhm.
that can literally make or break
Yeah, they can make or break the whole deal.
the whole thing. So understanding them, that's what gives you the power.
Right, to protect yourself.
To protect yourself, to handle risk the right way.
Yeah, to make sure you're not on the hook for something you never agreed to.
Exactly. Don't wait for something to go sideways and be like, oh, I didn't see that coming.
Yeah, if I had only known.
Exactly. You've got to be proactive.
Be proactive, know what you're getting into.
Yeah, when you understand how conditions work, you see those red flags.
Mhm.
You can negotiate better, maybe get better terms for yourself.
It's like having X-ray vision for contracts.
Right.
So the next time I am even glancing at a contract,
Yeah.
I'm not just looking for where to sign my name anymore.
No way.
I'm putting on my lawyer hat and I'm digging into those conditions.
Exactly. And ask yourself, what are the conditions precedent?
Right. What has to happen for this whole thing to even matter?
Exactly. What could get me out of this? What are the conditions subsequent?
Right, like those just-in-case clauses.
Oh, exactly. And what if things go a little sideways?
Right, because let's face it, sometimes they do.
Oh, they always do.
Yeah.
Is there some wiggle room, some flexibility with this whole substantial performance idea?
These are such good questions.
You got to ask them.
I mean, it's amazing how these little details
Right.
can make such a huge difference.
Huge.
This has been honestly eye-opening.
It's been fun.
It has. So for our listeners who've been with us on this journey, learning all about contract conditions,
Yeah.
what's the one thing you'd leave them with?
The next time you see a contract, it could be for anything. Your phone,
Your phone, yeah.
a car, whatever. Really read it.
Don't just skip to the signature line, right?
Don't do it. Look for those if-then scenarios.
Yeah, those are key.
What are the conditions? All of them. Precedent, subsequent.
Right. Are there any that scream dependent condition?
You might be surprised what you find. A little knowledge goes a long way.
That is such good advice.
Thank you.
Knowledge is power, and understanding these contract conditions.
Absolutely.
That is how you face any agreement with, like total confidence.
I love it.
Well, this has been another deep dive.
It has.
Thanks to everyone for joining us as we explored the wild world of contract law.
Always a pleasure.
Until next time, happy contracting, everybody.